Hello, everybody.
The same judge, similar to the co-defendant, Mr. Smith, I did discuss with Mr. Trice any possible conflict. Since they are co-defendants, I don't believe there is one. He's indicated he's okay with me moving forward, so we don't have to bring in a second attorney and wait to do this. Having said that, we'll waive the formal reading, stand mute to the charges, requesting a not guilty plea, the appointment of an attorney, and the PCC date.
Thank you very much. Good afternoon, Mr. Trice.
Good afternoon.
Mr. Trice, the court has just entered a not guilty, repeat, not guilty plea on your behalf. Court-appointed counsel is now noted and approved. That will occur through what they refer to as the IDSO office. Please keep an eye on your mailbox. If you do make your freedom today or any subsequent day, you will be receiving a notice directing you when and how to appear for a probable cause conference. Before that occurs, you'll be hearing from your new lawyer on this case assigned to you. They're going to want to reach out and do their best they can for you and team up with you so together you can determine how you want to manage this case. The court must set bond in this case, Mr. Trice. That's not intended to prejudge or punish you, but is required in order to ensure that you do reappear and provide any necessary protection for the public under any circumstances that present. In that regard, Mr. Lynch, what do you wish to share?
Judge, I'm aware that my client, it's alleged, was in possession of ammunition. The good thing is there's no allegations that he's in possession of any type of actual firearm. There's some question as to who the ammunition actually belonged to. That will be ferreted out at the exam, I would assume, by his counsel. My understanding from your honor is that he is on probation, I believe out of Wayne County. I would like the court to give him a personal bond. Should that not occur, we're asking the court for a $1,000 10% bond.
Thank you, Mr. Lynch.
He does work 4 jobs, Judge. I did want you to know that too.
When setting this bond, Mr. Trice, the court must take into account contacts with the community, employment, stable residence, and as well prior history, which in this case is extremely troublesome, and also the track record of an individual in terms of showing back to court. Mr. Lynch, as you suggested, and the court appreciates your candor as always, this man is already on probation and appears to already have a violation pending. And there are at least a half dozen or more bench warrants. The court has significant concerns in that regard. The court understands that there was no weapon, but the court also understands that there was still a prohibited item where it was, and a holster as well. There were controlled substances in the vehicle and other indications of activity afoot that is just not going to continue in the best interest of Mr. Trice as he continues on the path. These following conditions will apply to your release, Mr. Trice. You will appear as directed for all your future dates. You'll abide any valid order or judgment entered in this case. You're not to leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. Please do notify the court in writing of any change of address, telephone, or email. You will make reports to pretrial services. There will be no release without a GPS tether. No use of alcohol, marijuana, or any other controlled substance. No possession of a firearm or other deadly weapon or ammunition. Do not enter any business premises in the cities of Royal Oak and Berkeley except for work or medical purposes. You will submit to 1 ETG test for alcohol a week and 4 controlled substance tests per month. And at this time, notwithstanding Mr. Lynch, what I'm sure could at some level and at some point be characterized as somewhat mitigating circumstances, the overarching concern here is all the moving parts as well as the bench warrants. So at this time, the court will set a $20,000 bond, cash only, and that completes this arraignment. Mr. Trice, do you have any questions for the court or your counsel?
Yes, Your Honor. Can I get a 10% of? Can I get a 10% bond? Do I have to be on tether upon release? And like, I don't have no bad track record history. I go to all my court appointed or all my court dates on time. I've been on probation for all the county. I've been getting off probation for all the counties. I'm almost on probation in Wayne County. I didn't even know about a pending violation hold until a few minutes ago. And I take care of my family. I got a lot going on. Just want to get back home, to get back to my jobs and back to my family. I had no knowledge of the ammunition being in the car. It's already licensed to a CPL holder himself, and the station had called and verified who the ammunition truly belongs to. So I'm just asking, can I get at least a 10% bond or something lower, please, so I can get back to my family on time? Because I got a lot going on. I don't want no more trouble, and I'm already in.
Understood, Mr. Trice, and the court empathizes with your situation. However, the situation is in fact self-created. The court has concerns that you will not return to court. So the bond will remain as it is, and your IDSO counsel can certainly revisit the issue of bond at your first probable cause conference, but that completes this arraignment. Good luck to you, sir.
Your Honor, I'd waive any formal reading, stand my client mute, ask that a not guilty plea be entered on his behalf. Further, he would be requesting the assistance of appointed counsel.
Thank you. Hello again, Mr. Modok.
Hello, Your Honor.
At this time, the court is entering a not guilty, repeat, not guilty plea on your behalf. Court appointed counsel will be noted and approved. And Mr. Modok, what that means is you get mail on Tupper, correct?
Correct.
You're going to get a court date mailed to there if you make your freedom today. If it'll direct you when and how to appear for a free trial. And you'll be hearing from your new lawyer. They're going to have to send you an email and or a hard mail, but please keep an eye on your mailbox and your email. Do you understand? Okay, the court has to set bond now, Mr. Modok. You're quite familiar with that process. That's not intended to prejudge or punish you. This is a local ordinance under the disorderly series, but the court must set bond in order to ensure your reappearance and afford any necessary protection for the public. In that regard, Mr. Mitchell, what is it you would like to share?
Your Honor, my client is 57 years old. He does reside at the listed address in East Point. Your Honor, his full-time job is he watches his 3 grandchildren while his widowed daughter-in-law works. He does that so she can maintain her employment. Although he's had some contacts previously, Your Honor, he doesn't have any history of failing to appear. This is a non-violent offense. I don't think he's a flight risk, Your Honor. I would ask the court consider a personal bond and not too many bond conditions.
Thank you. In considering bond, the court must also consider the prior history, contacts with the community, employment, and propensity to return to court. While there aren't any apparent outstanding warrants of any significance that this court can glean, Mr. Modok, I'm not sure why you have such an ardor for the city of Royal Oak if you live in East Point, but you have been busy with this particular court. Mr. Mitchell, obviously you wouldn't have each and every piece of information, but there's 2 pages of ROA here, multiple cases. So in 2019, there was a 3-count ordinance misdemeanor. That was in February of 2019. Again, in June of 2019. Then in July of 2019. These are all ordinance misdemeanor issues, and they all seem to involve the same pattern or practice of behavior. September of 19, twice in September. December of 19, January of 20. Then we had a respite, and then July of 22. Multiple counts there. August of 22. Again in August. So 2 incidents in August. And again, these are all ordinance misdemeanors. None of these are parking or civil infractions or anything like that. Oh, strike that. So 2 in August of 22, another one in May of 23. And then apparently we took a break, but now here we are in August of 24. Mr. Modok, these following conditions will apply to your release. You will appear as directed for all your future dates. You'll abide any valid order or judgment entered in this case. You're not to leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. Please do notify the court in writing of any change of address, telephone, or email. You will be making reports to pretrial services. You will contact them within 24 hours of release. No use of alcohol, marijuana, or any other controlled substance. Do not purchase or possess a firearm or other deadly weapon. Do not enter bars, clubs, liquor stores, or any business premises in Royal Oak except for work or medical purposes. There will be 2 ETGs a week. There will be 2 controlled substance tests a month. And at this time, given everything that's in front of the court and the fact that while we have a presumption of innocence, we also have what could amount to and be construed at some point as similar acts evidence. The court is going to set a $5,000 cash or surety 10% bond at this time. That completes this arraignment. Do you have anything further for the court, Mr. Mitchell?
Nothing, Your Honor. Thank you.
Good luck, Mr. Modok. Please stay on the path.
All right.
Officer, anything further?
What time did I have?
Your Honor, he's asking for his bond again.
It's 5,000 cash, surety, or 10%. Thank you.
Thank you, Your Honor.
Thank you, officer.
Waive the formal reading. And lastly, Your Honor, she is requesting MIDC attorney. Ms. Keesan, can you state your name for the record, please?
Ashley Keesan.
Good morning again.
Good
At
morning.
this time, Ms. Keesan, a not guilty, repeat, not guilty plea is being entered on your behalf. Court-appointed counsel is noted and approved for the future. Ms. Keesan, today is not your last hearing, but your first hearing. So you
Yes.
will be receiving a notice to your address in Oak Park. It will direct you when and how to appear for your next court date.
Okay.
And as well, Ms. Keesan, Ms. Blakeney will want to reach out with you and work with you on this matter so you can act in your best interest. The court must set bond. Bond is not intended to prejudge or punish you, but is required in order to ensure that you reappear and afford any necessary protection for the public.
Okay.
Ms. Blakeney, what would you like to share with the court related to bond?
Your Honor, my client does not have a criminal history. She's 39 years old. She just was released from Sacred Heart Rehab yesterday. She did appear timely today. I do not believe she's a flight risk or a threat to society. I would just ask for a person.
Thank you very much. Ms. Keesan,
Yes.
Blakeney is an excellent attorney, but she can't alter facts that occurred in the past. So there have been some criminal contacts, one in 2002 and one in 2022. But the troublesome aspect of this matter, Ms. Blakeney, is that at least on a probable cause basis, the citation indicates that Ms. Keesan was unconscious on the sidewalk near 13 Mile Road and
Okay.
ultimately provided a breath sample of 0.47.
Okay.
So the court is concerned, Ms. Keegan, about your well-being and your health, as well as your commitment to return to court. Does that make sense?
Absolutely.
Okay. So at this time, these following conditions will apply to release. You will appear as directed for all your future dates, abide any valid order or judgment entered in this case. You are not to leave the state of Michigan without permission of the court. Ms.
Okay.
Keegan, please don't commit any crimes while you're on release status. The
No,
court is
sir.
going to require pretrial service supervision. Can you take this number down?
Sure.
Thank you. No use of alcohol, marijuana, or any other controlled substance without a
Okay.
valid prescription from a treating physician. You will participate in a monitoring program. You will participate in any aftercare
Okay.
recommended by Sacred Heart.
Yes.
You will not purchase or possess a firearm or other deadly weapon. You will not enter bars, clubs, or liquor stores.
Okay.
You'll be tested 2 times a week with an ETG, and there will be an initial drug screen.
Okay.
If that's negative, you need not test any further
Okay.
for controlled substances. If it's positive, you'll be tested 3 times a month. And at this time, the court will set a bond in the amount of $5,000 personal. What that means, Ms. Keegan, is we're taking you at your word that you've got matters squared away, that you're on a path, that you're
Yes,
working
sir.
steps or whatever you need to work for your own well-being, okay?
Yeah.
If you miss a court date, if you violate a bond condition, if you decide I'm going to start ignoring the reasonable advice of my esteemed counsel, life could get very complicated. You could end up owing the court $5,000 cash money and a bench warrant get issued for your arrest. So you're in a very manageable posture right now. The court's just entreating you that you need to keep it that way. Okay?
Okay. All right. Well,
Do you have any
thank you. I
questions?
appreciate it.
No
No,
worries.
not at all.
All right.
Thank
Take care now. Good luck to you.
Thank you so much. Thank you, Your Honor.
Be in contact. Thank you.
Be safe, be well, sleep sweet, and much love.